Lizzie Borden, middle of page 187. By now the bulk of the police testimony was bordering on redundant. With the exception of Mulcahy's sensation about the hatchet handle, it sounded as if the officers had all memorized the same basic script. Captain Dennis Desmond at first was no different. He agreed with Inspector Medley about the coarseness of the dust on the hatchet head. It was all dirty, he told Mr. Moody. That is, it was covered with dust, which was not of fine nature. That is, it was too coarse to be called a fine, which I mean it is. It wasn't any sediment that might have collected on it from standing there any length of time. It was a loose, rough matter, which might be readily pushed off or moved by pushing your fingers on it. It was not really dust, he said, but dirt? That was a minor quibble, considering that everything he said about the box was the same, 14 or 15 inches long, maybe 4 inches wide, filled with dusty cast-off tools and bolts and nails, coarse or fine ash dust or dirt. The key point for the prosecution was that the dust inside the box did not match the dust on the hatchet head, and Captain Desmond was positive about that. But what he said next about Inspector Medley taking the hatchet down to the police station stopped Mr. Moody's questioning cold. I gave it to him wrapped up in a newspaper. Desmond had no way of knowing. He just contradicted Officer Mulcahy, and so Governor Robinson did not pounce and risk putting the witness on guard. Gradually he worked his way towards the hatchet with question about the search Desmond had led on August 6th. Was he certain he had done the wrapping? Robinson wanted to know. Positive, Captain Desmond said. I got the paper from the water closet. We're there to do it up with. Robinson handed him the hatchet head and a piece of brown paper, just as if he'd offered Inspector Medley. Well, won't you wrap it up about as large a piece of paper? I shall have to get a full-size newspaper to do it, Desmond said. Much larger than that, sir. Desmond settled for a Boston Globe, though that was still not big enough, he said. Then the entire court watched in bemused awe as Captain Desmond slowly demonstrated how he'd rolled up the very same hatchet Inspector Medley had sworn to wrapping in brown paper. It might have been less ridiculous if the two policemen parcels resembled each other even slightly, but Medley's brown paper packet had looked like a wedge of pie, while the Sunday Boston Herald called Desmond's a great newspaper bundle big enough to conceal a pair of longshoreman's shoes. First the hatchet handle, now this. By the next day, the Fall River Police Department was the laughingstock of all the papers. The handleless hatchet, now generally known as the hoodoo hatchet, continued its demonish pranks in the trial of Lizzie Borden for her life today. The Sunday Boston Herald ribbed in a special dispatch. It chopped another great hole in the case, of which it is the most important feature. Day 7, Monday, June 12, 1893. After a week of testimony, there was still no greater evidence in the case against Lizzie Borden than her own inquest testimony. As he had done at the preliminary hearing, District Attorney Knowlton wanted to read that mass of inconsistencies into the record to let the jury hear for themselves that Lizzie Borden had wavered and hesitated and changed her story. But that testimony, the defense argued, was not admissible. The issue hinged on whether Lizzie's statements at the inquest had been made voluntarily, a question that 3 justices had to decide. And so, shortly after 9 o'clock, the jury was sent from the room, while for 2 hours Governor Robinson and Mr. Moody presented their arguments. According to Robinson, although Lizzie willingly obeyed the summons to appear at the inquest, the crucial fact was that she had testified unaware that she was already under arrest in all but name. Police surrounded her house day and night almost from the instant the crime was discovered. The mayor himself had instructed her to stay inside. Worst of all was a secret warrant waiting in Marshal Hilliard's pocket throughout the inquest. The very existence of that warrant proved that the authorities already believed Lizzie guilty, and yet they called her to testify. Her lawyer was not present, nor had she been informed of her right not to testify. Rather, Robinson said the city marshal stood at her shoulder, authorized and directed to lay his hand upon her at any instant and make her a prisoner. After Knowlton had gotten all the information he could from her, Lizzie was not allowed to go free, but was held in the matron's room until a new warrant was drawn for her arrest made official. If that is freedom, Robinson thundered, God save the Commonwealth of Massachusetts. And if anything said by a defendant under those circumstances was termed voluntary, he proclaimed, then the very meaning of the word must be changed. The way the authorities had deliberately dodged the Constitution, Governor Robinson admonished, was worse than burning a dress. May it please your honor, I have very little to offer a reply, Mr. Moody began Governor Robinson's argument. He acknowledged it is magnificent, but is not law. Given the circumstances of the murders, Moody believed the court had done nothing but its duty. Lizzie Borden had been summoned in the usual way, and she had appeared. Lawyer Jennings requested to be present and had been declined, Moody said, because the law expressly gives the courts the power to decline it. As far as being informed of her right not to incriminate herself, Moody also acknowledged that she was not cautioned in the courtroom before Judge Blaisdell. However, Lizzie had been permitted to consult with Lawyer Jennings before testifying, and Your Honor can have no doubt that the reason why the caution was omitted at the beginning of the testimony was because that subject had been thoroughly talked over between counsel and client, and she knew and understood her rights. It would be an insult to Lawyer Jennings to presume otherwise. Further, Robinson's argument assumed that the only motive for the inquest was to wrench a confession from Lizzie Borden. While Moody asked, didn't anyone assume that the inquest gave Lizzie Borden as much chance to clear her own name as it had given Bridget Sullivan? Similarly, Moody argued the police surrounded the house as much to observe Bridget Sullivan and John Morris as Lizzie Borden. That was their duty. There was nothing in the warrant in Mr. Hilliard's pocket which changed her legal position or her legal liabilities one iota, Moody said. If the question was whether Lizzie had testified voluntarily, how could a warrant she did not even know about affect her willingness to take the stand? When Moody finished, the three justices withdrew, and for an hour and a half the court waited for an answer. Lizzie Borden leaned forward as they filed back into the bench. From the agreed facts and the facts otherwise in evidence, Chief Justice Mason said, it is plain that the prisoner at the time of her testimony was, so far as relates to the question, as effectually in custody as if the formal precept had been served. There was more to his explanation, but only the last 4 words mattered to the hushed spectators. The evidence is excluded. It was a triumph for the defense. The pairs, the sinkers, the upstairs, downstairs absurdities, not one word of it would reach the jury. Lawyer Jennings and Colonel Adams beamed. Governor Robinson's face was when giant I told you so. Opinions and emotions erupted throughout the courtroom until the sheriff pounded the gavel for order. And what of Lizzie Borden? For a moment, nothing. Then the realization flashed upon her. One bright instant of exultation lit her face, and Lizzie Borden burst into tears. She pressed her handkerchief into her eyes and buried her face in her fan, but there was no hiding it. Her whole body shook with the force of her relief.